Hello?
Good afternoon, sir.
Good afternoon, sir.
Yeah, good afternoon. How many are you in class already? Sorry, let me see. English 61. Okay. Let me give you people another 5 minutes or 2 or 3 minutes. We're just waiting for them to be. Hmm? I'm waiting for them to be up to a given number. Okay, maybe we can start.
Yes, sir, we can start.
And somebody remind me of where we stopped last time. Yes, there are questions I want to ask. Remove it, remove it. And somebody remind me where, sorry. Uh, this semester, how do we test you people? Say,
So the class rep will
is
send.
there
So give us
any
assignments.
Sir, assignment.
so that you can copy yourself?
No, it
Yes,
will be group
No, sir, we
assignment.
can't
assignment,
copy
sir.
ourselves.
Uh,
Work,
So you
sir.
can,
Group work, sir. Group work.
Individual assignments, sir.
Please, personal assignments. You can't even give us
Individual
this much.
assignment, sir,
Group
please.
Individual
work.
assignment,
Please.
please.
Group work.
Thank
We
you,
copy
sir.
ourselves.
Don't
Individual.
copy each other. You can give us different
Individual
topics.
assignments, sir.
You can write
Group
on
work,
different
please.
aspects of conflict of law, sir. But please, individual assignments, sir.
we can do individual assignments. However, for ease of marking and to reduce your workload, group assignment is a viable alternative.
Yes, sir, we agree.
anyway, I will discuss with my colleague. He's in charge of examination. My own is to teach. In those days when I used to be very ready, I will tell you that you will do CBT and give you some objective questions that will test your understanding of what we have been saying. I don't know. I don't know whether I'm ready for that. Okay. When is your own class? When is your own class doing exam? Hey, I'm supposed to even send notice. When is your own class doing exam?
Good afternoon, sir. We have our exams. Rather, our exams are starting March 17.
March 17. What are we going to be doing between now and then?
So our lectures end
Do I have
on
only lectures end when?
Friday, February 14.
For every class?
Yes, sir.
You didn't tell me now.
I'm so sorry, sir. I thought you.
I can't finish that on Friday, February 14. No. I thought that you have all the time in this world.
Not at all, sir. But we can arrange for.
Anyway, you don't have a choice. Oh, because we have one whole topic left. Even this one, we have not gone anywhere. We've not gone anywhere. Bring my laptop. So we were talking about nullity, the issues falling under capacity. Is that not so? Hello?
Yes, sir. Yes,
Yes,
sir.
sir.
Okay. I'm coming. I want to open my slide. I was using a slide to teach you people. Let me see if I still have it handy. Okay. Okay. So we are looking at we are looking at capacity or what in internal marriage law you people call essential validity. Okay? So if any of the issues falling under that becomes the basis of nullity, how do the court go about it? We look at the debate, we said the connecting factor is very clear, is domicile. So what is the meaning of domicile in the context? And we look at the debate between Cheshire and Daisy. Daisy saying that it's antinuptial domicile, and Cheshire saying that it is matrimonial home domicile. How much do the cases help either theory? We have seen that the cases do not seem to help any of them in such a way that you can be convinced that this is what the courts are doing. So invariably, the two remain theories, not practice. Okay? What we as lawyers are bound to do is to follow precedent. So if you look at the fact of cases and you see that they are at all fours with a case you have seen before, instead of you suggesting that you are using Cheshire or Dicey proposition, just follow that case. You know that that's the one we at common law will do. We will follow the previous case. We will not follow the theoretical explanation that the case is said to justify. So we have looked at, we have looked at consanguinity and affinity. We have looked at lack of age, pug and pug. Yes, previous marriage, sure and good, padoletia and padoletia. Did I discuss any of these two cases last time? Hello?
Yes,
No,
You
sir,
sir.
we
asked
did
us
not.
to.
We're about to.
No,
We're
sir.
about to discuss it.
Yeah, we
Okay.
just listed the cases, sir.
How can previous marriage become an issue of nullity? I think I explained it to you that suppose the domicile or forum does not treat the previous marriage as a marriage. Okay? A subsequent marriage done elsewhere that meets the test of marriage of either the forum or the domicile might be regarded as a valid marriage. But if the forum or the domicile accepts the previous marriage, then the subsequent marriage will be treated as an invalid marriage, being one that is done during the subsistence of another one. Okay? So that is how previous marriage becomes relevant. Okay? So the cases that we normally look at on that one is the case of Shaw and Gold. Gold is Gould. Is it gold? Gold. The facts. A man and a woman, both domiciled in England, married in England and separated soon afterwards. The marriage was dissolved by the Court of Session in Scotland and the woman then married a domestic Scotsman and lived with him in Scotland. The divorce was not recognized in England because the first husband never lost his English domicile of origin. The House of Lords held that the second marriage was void, although it was valid by the law of the second husband's domicile and by the law of the intended matrimonial home. Lord Cranworth said, if the first marriage there was not dissolved, there could not have been a second marriage. If the first was dissolved, there was no capacity to contract a second. Okay? So Daisy submits that this case illustrates its own position, that it is antenuptial domicile. Okay? I've said, let's forget about the theory again and look at what the cases said. Because conflict professors, how did somebody describe conflict experts? Have you read anywhere where conflict experts are being described by English judges or English text writers? I think somebody said that they are erratic or something. Eh? There's a particular word that is used to describe them. They give you a test as difficult as mathematics. Trying to rationalize a case on the basis of a theory can be as difficult as solving a tough mathematical problem. But let's look at pathology. But meanwhile, you understand the fact of Shaw and Gold. Let's look at pathologia, lecture and pathologia. A man domiciled in Italy was divorced from his first wife in Mexico. This divorce was not recognized in Italy. He then went to live in Denmark. And during a one-day visit to England, he went through a ceremony of marriage with a woman domiciled in Denmark. They both returned to Denmark to live. And later, the man, still domiciled in Italy, petitioned the English court for a decree of nullity on the ground of his own bigamy. Sir Jocelyn Simon P. held that since the Mexican divorce was not recognized in Italy, the man had no capacity to marry by the law of his domicile, and he expressly approved the rule in Dicey and Morris treaties, stating the dual domicile test. He declined to consider the possibility that the marriage might be valid by the law of the intended matrimonial home. This decision is thus a strong, according to Morris, is a strong authority for Dicey's position. Okay? So the next point we are looking at is remarriage upon void foreign divorce. Remarriage upon void foreign divorce. We will go to the topic we call recognition of foreign divorce decrees. Okay? So, if one party goes to one country, maybe on the basis of their own rule, whether residence or habitual residence or whatever, is able to file a divorce petition. You know, there's a difference between divorce and nullity. When you are filing for divorce, you are not saying that the marriage was void ab initio. You are saying that the court should exercise its power of its judicial power to terminate the relationship. So everything about divorce is local. The court will not use foreign rules. Once the court believes that you have met a requirement for petitioning, the court will dissolve the marriage on the basis of the territory's own rule or regulation for divorce. But you stand the risk of another country not recognizing that divorce. That's what we call a limping marriage. You get a marriage dissolved in country A, you go to country B says, you are still married though. That divorce is a nullity. The day you get back to the country where you get the divorce decree, you can behave as if you are no longer married. But when you move to another country and the country examines everything, says, no, we don't accept the basis of the divorce that was granted. So the court, the place you go to after the divorce fails to recognize your divorce decree. Okay? If you then remarry, what will be the status of that marriage? What will be the status of that marriage? Conflict of law cases treat that question as a question of capacity and applies lex domicili. What is the meaning of lex domicili? Is it you judge that question by the domicile of matrimonial home, or you judge it by the antenuptial domicile? Now let's look at the case of Perini and Perini. Perini and Perini. In Perini and Perini, an Italian husband married in Italy a woman domiciled in New Jersey. She obtained a decree of nullity from the New Jersey court on the ground of want of consummation. This decree was recognized in England, but not in Italy. Later, the husband, still domiciled in Italy, went through a ceremony of marriage in England with an English woman. It was held that the remarriage was valid. The 1971 Act was immaterial as it did not apply to foreign nullity decrees. In Lawrence and Lawrence, a woman domiciled in Brazil obtained a divorce in Las Vegas, Nevada, and the following day, he remarried in the same Las Vegas a man domiciled in England. By the wife's Brazilian domicile, the divorce was invalid, and she had no capacity to remarry. The Court of Appeal held that as the divorce was entitled to recognition in England, the parties to the divorce were free to remarry. Okay? There is a statute governing the matter in England now, which is not part of our law. So I won't bore you with that. The next issue is remarriage after a void foreign divorce. The case of Scribble and Unger.
Excuse me, sir.
Yes?
Sorry, please, I have a question.
What is the question?
From this part that we just finished discussing, where there's a remarriage after a valid divorce, I didn't get the conclusion, sir. Are you saying that it will be a ground for nullity or is not a ground for nullity? I don't understand.
Where there is a remarriage after a previous marriage had either been nullified or dissolved by a court decree, okay, that remarriage will be haunted by the validity of that divorce or nullity decree. Whether that divorce or nullity decree, so whether that remarriage would be valid or not, on the basis that there was a nullity and divorce decree, will depend on domicile. Okay? Will depend on domicile. Okay? So that's what the cases are illustrating. I've told you, if your capacity cannot carry it, forget about the debate between Cheshire and Morris. Just be able to illustrate that the domicile, that domicile governs the issue. So let's go over the case again. Lawrence and Lawrence. A woman domiciled in Brazil obtained a divorce in Las Vegas, Nevada. And the following day, she remarried in Las Vegas a man domiciled in England. Clearly, by Las Vegas law, the marriage was valid, isn't it? Hello? Is
Yes,
the marriage valid by Las Vegas law?
Yeah. Yes, sir.
But we are not going to use Las Vegas law to determine the validity of the marriage. Who can tell me the reason why?
Because it's not a question.
Because the matter is governed by lex domicili, not lex loci celebrationis. Do you understand?
Yes, sir.
So the question now is, what is lex domicili in the context of the facts? So the question told us now that by the wife's Brazilian domicile, by the wife Brazilian domicile, which wife are we talking about? Which wife are we talking about?
The one that got divorced in Brazil.
Yes. The wife that was the wife in both the original marriage and the remarriage. Okay? The marriage was dissolved in Las Vegas, but Brazilian law, which is a domiciliary law, the divorce was invalid. Under Brazilian law, a domiciliary law, the divorce was invalid. So by Brazilian law, our own domicile, she was not going to have any capacity to remarry. But the Court of Appeal held that since the divorce was entitled to recognition in England, okay, the parties to the divorce was free to remarry. What is the connection of England with the case? From the facts, England was only connected with the case because it is the domicile of the new man she married. It is the domicile of the new man she married. So what does that decision, what does it justify? Is it Cheshire's theory or Dicey's theory?
Cheshire's theory.
Yes, it justifies Cheshire's theory. Okay, Morris is Cheshire's friend. Morris is Dicey's friend. So he was hesitant in saying that that case justifies Cheshire's theory, which is the matrimonial home domicile. Because if it was to be antinuptial domicile, an English court will declare the marriage a nullity, because an English court will say, by the Brazilian law, domiciliary law of the wife, she was still married to somebody else. So the marriage would then be a nullity. But it is because the English court seem to have accepted that the relevant theory is the matrimonial home domicile. that it will recognize that since the husband was domiciled in England, the marriage was valid. So if you want to illustrate matrimonial home domicile, Lawrence and Lawrence will be a very good example. Okay? But you might come across other cases where it will be difficult for you to say they followed matrimonial home domicile. But clearly in Lawrence and Lawrence, it was matrimonial home domicile that they followed because they negated the negative implication of the Brazilian domicile of the wife. Okay? And accepted as overriding the acceptance by England, the husband's domicile. Okay? So we move to the marriage after void foreign divorce. The marriage after void foreign divorce. Squibble and Unger. A husband and wife, both Jews, were domiciled in Hungary. They decided to emigrate to Israel. While en route to Israel, they were divorced by a Jewish get or extrajudicial divorce in Italy. Listen to the fact very well. There's something else. I want you to teach people as students of conflict of laws from the facts of this case. I will discuss it later. Look at the question. Look at the facts. Squibble and Unger. A husband and wife, they were both Jews. They were both Jews, but they were domiciled in Hungary. They decided to emigrate to Israel. Okay? They want to go back home. Or they want to go back to the new home that the powerful nations of the world created for them. So when en route to Israel, they were divorced by a Jewish get, an extrajudicial divorce, just like Islamic divorce that some people say is a pronunciation of 3 talaqs. So the Jews also have something like that. Okay? So they were divorced by Jewish gets. That was done for them in Italy. Okay? So they were trying to return to Israel and route Italy, even though they were ordinarily domiciled in Hungary. Okay? So a Jewish get was pronounced between them in Italy. Of course, you know that they are not domiciled in Italy. They are just passing by. They then separately acquired the domicile of choice in Israel. So each of them now went to Israel and acquired the domicile of choice. The wife married a man domiciled in Ontario during a temporary visit to that province, Ontario in Canada. Now, this get that took place in Italy was valid by Italian law, but not valid by Hungarian law. And they were both domiciled in Hungary at the time of the get. Okay? So the get will be valid under the law of Israel. They are newly acquired domicile, not valid under the law of Hungary. Their domicile as at the time it was pronounced, but valid under the law of Italy, the place where the gate was pronounced. Okay? What of Ontario, where the wife remarried? Ontario too did not recognize a gate as a valid divorce. So what happened to the marriage? The court held that the marriage was valid because immediately prior to the remarriage, the wife's status by the law of her domicile was that of a single man. Okay? So this one teaches a number of things. Okay? This one teaches a number of things. The first one is that domicile is a mobile connecting factor. And once domicile of choice is recognized, the propositors will be assessed by that domicile. Okay? It also teaches that the question of remarriage after a void following divorce is governed by domicile. Is governed by domicile. The remarriage was not valid because the divorce was pronounced in Italy. If that is the reason, we will then say that the lex loci celebrationis, okay, the locus of the divorce will matter. But the locus of the divorce was not the relevant issue. It was the domicile of the spouse who benefited from gets. Okay? Now, what is the bigger lesson in all of this? The bigger lesson in this is that you do not flatly determine validity of transactions done under religious law by rules of thumb. You do not determine validity of transactions or relationship formed under religious law by rule of thumb. You saw how the Jewish gate was treated. Okay? Each of the country had treated it on the basis of their recognition of it. Okay? Hungary did not recognize Jewish gate, but it allowed Jewish couple to marry under Jewish law. The meaning is that you do not throw away religious law in a blanket manner. If you have a public policy against some aspect of it. That public policy will prevent you from recognizing that aspect. But you will not say that because Jews were domiciled in Hungary, they cannot transact under Jewish law. If anybody understand this very well, you can advise our governments in Western region that their argument is outdated. The argument is outdated. The only ground upon which you can exclude relationship or transaction done under otherwise religious law is if you have a public policy against it. You cannot have a public policy against the application of the whole of a religious law. Okay? You can only have it against particular rules. Okay? So that is why Hungary, though permitting Jews to marry under Jewish law, will not recognize Jewish get. Whereas Israel will both permit them and recognize it. Okay? Let us leave nullity and move to polygamous marriages. There are other issues in nullity. We can't cover everything. Go and take a basic text and read the other issues we have not discussed. Some of them very interesting, like physical incapacity. Physical incapacity. Is physical incapacity a matter of essence or a matter of, it can't possibly be a matter of form? Physical incapacity under Nigerian law, isn't it a matter of essence? Will a woman be able to, will a woman be able to seek knowledge of marriage on the ground that the man cannot do in Nigeria?
Yes, sir.
Under our law. And the man on the ground that, on the ground, the man too can do so on the ground of, can he do it on the ground that the woman does not have a hole?
Yes, sir.
Good. So physical incapacity is a ground of, an essence. So are there countries that will say that a man who cannot do can marry? Do we have any country whose own law will be different? He can still marry you, or you can still marry him, so as to be doing what? With him or her. There's some very interesting cases on those areas. Go and read them. Reneville, the Reneville versus the Reneville. The Reneville and the Reneville. Go and read that case. Okay, at any rate, there are two. Physical incapacity can be divided into two. Impotence and willful refusal. Okay, let's leave that. Let's go to polygamous marriages. Polygamous marriages. I'm treating polygamous marriages because I want to show you how patently wrong our courts were in Fonseca and Passman. Okay? You see, if you understand this subject very well, you will know that your own attitude to a matter may not matter if your law is not the governing law of the relationship. What did I say? Your attitude to a matter may not be relevant if your law is not the governing law of the relationship. Different countries have different attitude to polygamy. But in having those attitudes, the civilized ones among them will know that we have to condone or accept people who are domiciled in countries that have a different approach. So you might have a country whose internal law forbids polygamy, such as England, most of the European countries, United States of America, and all of that. But because they are a civilized country, they will accept that people may be connected with another country whose attitude to the matter is different. So when an issue comes before them between foreigners who have contracted marriage abroad that is either polygamous or potentially polygamous, they are not going to willy-nilly determine the case by their own internal law. They are going to use their conflict rules. They are going to do what? They are going to use their conflict rules. Okay? If the governing law is not their law, they will freely apply whatever the governing law says. And it is the same twin test. It is the same twin test that we have been looking at in determining valid monogamous marriage that they will use. Do you understand? The same twin test, meaning that as regards formality, whether a polygamous marriage was valid or not will be judged as regard to formality by the lex notis celebrationis. So, whereas England does not permit English domiciliary to enter into polygamous marriage, where persons domiciled in foreign land are before an English court and seek reliefs pertaining to polygamy, the English court will not say, because we do not know polygamy. Those of you who did marriage law, they will normally give you, what is that case? What is that famous case? Height and height. Can you remember height and height? Hello?
Yes, sir.
Family law people. Height and height is the
Yes,
case where it is the foundation of the rule against polygamy under English law. Okay? But despite the fact that the court decided in height and height that it will not recognize a polygamous marriage between persons, both or one of whom is domiciled in England, the English court will be willing, okay, to entertain an action relating to reliefs appertaining to polygamous marriage, where one, the marriage was celebrated in a foreign country that recognized polygamy, lex nocis celebrationis. And two, the couple are domiciled. The couple are domiciled in a country that does not forbid them from entering into a polygamous marriage. Okay? So those are the two tests. Those are the two tests. Okay? Now I will give you the very interesting case of Hussein and Hussein. Because we don't have time, I'll give you the case of Hussein and Hussein. And you see somebody was singing. I say somebody, Tule say somebody, Daleru. A civilized person with knowledge of conflict of laws will use it to solve problems. But another person with so little knowledge of the subject will use it to create problems. Now look at what happened in Hussein and Hussein. In Hussein and Hussein, a marriage was celebrated in Pakistan. Pakistani law, of course, permitted polygamy if the couple are Muslims. Okay? Now, the couple were Muslims in that case, and they did the marriage in Pakistan. But one of them, the man precisely, was domiciled in England. And I've just told you that Ida Hyde so well decided that polygamy is unknown to English law. As a matter of fact, they have a public policy against it. Okay? So, a petition was filed under their own Matrimonial Causes Act for nullity of the marriage. Not divorce, but nullity. On what ground? On the ground that the marriage was a potentially polygamous one, which an English domiciliary, even if he was a Muslim, was not qualified to enter into. Before I give you the judgment, suppose you are the judge, how will you decide the case? Suppose you are the judge, how will you decide the case? English law forbids polygamy for English domiciliary. Mr. Hussein, though a Muslim, was an English or is an English domiciliary. English law does not forbid Muslim marriages. It does not forbid. It forbids polygamy. So this man went to Pakistan and entered into marriage that is polygamous in nature with a Pakistani who is domiciled in Pakistan. Okay? So one of the two of them later filed a petition in England, not for divorce, but for nullity, arguing that since the husband was was domiciled in England, he lacked the capacity to enter into a polygamous marriage. Remember what I told you? The two tests are still relevant. As regards formality, a polygamous marriage is valid if it was celebrated in a territory that allows it. As regards capacity, a polygamous marriage is valid if it was entered into between persons whose domicile law permits it. And what is the meaning of domicile? Daisy says it's antenuptial domicile. Cheshire says it's matrimonial home domicile. If you are applying Cheshire's matrimonial home domicile, you will only be looking at the domicile of the man. If you are applying antenuptial domicile, you'll be looking at the domicile of the man and the woman. So you are the judge. The case is before you. How do you decide whether that marriage in Pakistan was valid or not? Yes, let's be practical. Before I tell you what the ingenious English judges decided in that case. Hello? Hello?
Hello, sir.
Yes, who can attend? Who can be our judge?
Okay, sir, from my understanding of what we've learned, I'd say the English courts would hold that the marriage was null and void on the basis that the marriage did not fulfill the twin test, particularly the second test, being that no matter what aspect you look at it from, either the antenuptial or the other sense, the man's domicile, which is England, does not allow for a polygamous marriage. Therefore, it will be null and void on that basis.
Beautiful. 90% of analysts will arrive at that conclusion. I can assure you that a Nigerian bar and bench person will quickly say the marriage is enough. We like destroying things here. We like destroying things. Okay? But do you know what the court decided? Listen to the decision of the court. The English court said that, well. What is polygamy itself? Polygamy or polygyny simply permits the man to take a second or third or fourth wife. Is that not what it is? Hello?
Yes, sir.
So they said that if a man If an English domiciliary enters into marriage in Pakistan, you are going to judge the validity of the polygamous marriage not by English law, but by what? That is as for formality. You are going to judge the validity of the marriage by the lex loci delicti, lex loci celebrationis. Is that not so?
Yes, sir.
So the judges said on that score, the marriage was valid because it was celebrated in Pakistan that allows polygamous marriage. Then on the question of capacity to enter into polygamous marriage, you are going to judge that by the domicile law. And what does the domicile law of both parties, of either spouse, say? Yes, the man in England, the man domicile in England, his law permits him from taking a second wife. Do you understand? Do you understand the reasoning of the judge?
No.
Shall come
They
from
said
capacity.
what the English law forbids an English domiciliary from doing is marrying a second wife. Okay? And as far as they are concerned, it is when he wants to take the second wife that his domiciliary law will come to operate to buy him. Do you understand?
Yes, sir.
Yes,
Yes,
sir.
sir.
Yes,
Yes, sir.
sir.
Then they said that as for the woman who was domiciled in Pakistan, even Islamic law does not permit him to take a second husband during the subsistence of this marriage. So for them, the marriage should simply be treated as a monogamous marriage. Do you see their logic? Do you see the logic of the English judges? These
Yes,
are
sir.
judges.
Yes, sir.
Yes, sir.
These are judges who believe that saving a transaction or a relationship, insofar as there is a logical explanation you can give to do so, is the best thing to do. So the English got there that, well, the marriage in Pakistan was potentially polygamous. But as far as we are concerned here, an English domiciliary will not be violating his domiciliary law if he's taking a woman under that marriage system as his first wife. Okay? Though Pakistani law of the marriage might permit him to take a second wife, we will wait for him when he wants to do that and tell him quickly that your domiciliary law does not permit you to take the second wife. So, for all intent and purpose, we will treat the Pakistani marriage as a monogamous marriage, even though it is a potentially polygamous one. That's what the English court did in that case. Now you can contrast that with our own dear courts. In the case of Fonseca and Passman, the man was a Portuguese. presumably also domiciled in Portugal. We were not told that he was married before. Or we were not told that he remained in a subsisting marriage. All he did was to marry our own daughter under our customary law. We, right before us in our own court, when the issue arose as regards the legitimacy of the children born to him under that marriage, we opened our wide mouth and pronounced a rule that we have no authority for, that foreigners had no capacity to marry under customary law. I searched everywhere for the basis of that rule. I read somewhere that, well, the basis of the rule, I see that the rule is not internal to customary law. Is it internal to customary law? Do we have any rule in our different customary law system that our guests cannot marry foreigners? Somebody should answer me. In the custom of your community, are you forbidden from marrying foreigners?
No, sir.
No.
So the basis of that rule is not internal rule of any customary law in Nigeria. Do you agree with me?
Yes, sir.
Yes, sir.
Okay, listen. Let us ask again whether it is the provision of any statute. Here, I've read two different attempts to justify it. The first one is derived from the jurisdiction of the customary court laws. The customary court laws. The customary court laws will usually provide that the court cannot entertain cases between Nigerians and non-Nigerians. If this is deemed to be the reason why we say foreigners cannot marry under customary law, then it is very, very unfortunate. Very, very unfortunate. I would say that maybe we put our reasoning ability somewhere else and was just trying to pronounce rule of the thumb. For God's sake, if the customary court law does not have jurisdiction over a native, does that mean that there is no other court where issues having to do with his transactions with natives can be litigated? Okay. You are also doing land law, isn't it? If you have not gotten there, I know that your lecturer will teach you the jurisdictional issues arising under the Land Use Act. Because mine taught me when I was at your level. And they will usually teach us that some provisions of the Land Use Act said that it is customary courts that will have jurisdiction if it is a customary right of occupancy you are fighting about. Is that not so? Who can tell me the section in the Land Use Act? Abi, you have not got in there.
No, it's not conflict of law issues.
Okay. Then a number of cases came where the subject matter was customary right of occupancy. But the High Court decided the matter. And for the first time, the issue was raised in the Supreme Court, whether the High Court had jurisdiction to entertain the matter, the subject being a customary right of occupancy. Okay? In the first line of cases, it was decided that on that basis, the entire case collapses. The High Court did not have jurisdiction because statute vested jurisdiction of the customary court, blah, 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 ibim. Until someone who has read wider pointed to the courts that this decision is wrong. Why is the decision wrong? Because Section 236 of the 1979 Constitution, which is the same as Section 272, is slightly different because at that time, even the Federal High Court was treated as a court inferior to the State High Court in terms of jurisdiction. Section 236 of the 1979 Constitution gave the State High Court unlimited jurisdiction. So somebody just needed to point the attention of the court to that, to say, look, you do not understand. The court that decided this matter is a court of unlimited jurisdiction. And the meaning of unlimited jurisdiction is that you have both the jurisdiction that is expressly given to you and the one that is not given to you. You have the jurisdiction that is even given to other courts. For those ones, you are said to have concurrent jurisdiction with them. For the one that is not given to other courts, you have jurisdiction. And then you have jurisdiction in respect of the one that you are specifically empowered to do. So since then, plethora of cases have said, yes, though the Land Use Act says it is the customary court that has jurisdiction on resolving disputes relating to customary right of occupancy dispute. Nevertheless, because the State High Court has unlimited jurisdiction, a customary right of occupancy dispute that commences in the State High Court is correct. So, what are we saying?
Sorry, sir, what is the case?
Well, I can't remember the cases, but if you go to the note I gave you people, I don't know whether I taught your class legal system very deeply. You know, I didn't. I've retired from teaching legal system in the second semester. We normally teach it under conflict of jurisdiction between federal and state high court. Okay? So you will see cases like, I think, Sadiko and Salati, or there are a number of cases on the issue, but we are just learning lessons from those cases to understand the status of the State High Court as a court of, in my words, unlimited residual, a court of unlimited residual and concurrent jurisdiction. The meaning is that if the customary court laws, because they are talking about foreigners who deserve better judicial process. So if the customary court laws says they will not have jurisdiction over foreigners? The simple answer is that if foreigners become involved in matters of customary law, the state high court can simply take up the matter in the exercise of their unlimited residual jurisdiction. So, to conclude, that because customary court laws forbid customary court from entertaining foreigners' dispute, even if it is governed by customary law, therefore, foreigners lack capacity to enter into relationship with natives under customary law, is to pronounce a logical nonsense. So that is to knock off that as the basis. I read somewhere else too that maybe the basis is the rules of internal conflicts contained in the various ICON laws. Okay? Those are the rules that says that if a transaction is entered into between a native and a non-native, the presumption is that that transaction will be governed by English law. So how do you utilize that one? Okay. In the first instance, a marriage is not a transaction. Marriage is not a transaction, it's a status relationship. A status relationship. So those rules that are talking about transactions between native and non-native cannot apply to marriage between native and non-native. Secondly, if you say English law governs, you probably mean that the whole of English law, including its conflict rules, will govern the matter. But by far, the real problem with Fonseca and Passman and its line of cases is that those who decided the case did not quite appreciate that as far as the question of marriage is concerned, when once a foreigner or somebody who is domiciled abroad is involved, they have already indicated a foreign element, which takes the matter away from internal conflict to private international law. The logical thing to do is to apply our conflict rules to resolve the issue. If the court had applied conflict rules to resolve the issue, how would they have decided it? A polygamous marriage, whether you call it customary, you call it Islamic, you call it whatever, English law regards all of them as polygamous. The problem of the English people with the marriage is not the ceremony. It is the fact that the marriage is permitting the man to take a second wife. So they are all regarded as polygamous marriage. So our English conflict rules, which we inherited, would have told us that our customary marriage, law marriage, is a polygamous marriage. If it is celebrated in our country, then our country's law will govern its validity as to form. So if you ask that question, you will tick the marriage. The Nigerian law permits polygamous marriage. And we have said here that there's no statute that forbids our children from marrying foreigner, whether they are male or female. Okay? And there is no rule of customary law that forbids our girls from marrying foreigner or our boys from marrying foreigners as wives. So on that account, the marriage will be valid. Then, as regard capacity, it is the domiciliary law of the parties that will determine whether the marriage is valid or not. The wife was domiciled in Nigeria. Our law does not forbid her from marrying foreigner. Okay? The man was domiciled in Portugal. Following Hussein and Hussein, if the man was not doing the marriage during the subsistence of a previous marriage, then the only implication of marrying our daughters under our customary law that gives him the right to take a second wife is that he will not be able to exercise that right. That will be the correct decision. But till today, nobody can convince us as to the exact reason why the unfortunate children were deprived of the right to inherit their biological father because he married their mother under customary law. We are not told that he had a subsisting marriage when he did that. If he had a subsisting marriage when he did that, of course, the marriage would be a nullity. But I check the facts again to see whether anybody will say he had another marriage subsisting in Portugal. We are not told. So Fonseca Passman was an injustice done to our own daughters by our own court. Okay? There are other things. But I move to the last topic. Still under marriage. Please let us finish it today. We are not in a hurry, are you? The last topic under marriage, I've already discussed divorce with you now. I told you that the divorce is a non-choice issue. What do we mean by when we say divorce is a non-choice issue? It's not an issue where you apply conflict rules. You only apply internal law. So if a person is qualified to file a petition for divorce in Nigeria, it is our Matrimonial Causes Act that will apply to his release.
Sorry, sir, please, we have another class.
You have another class. Anyway, you are not in a hurry. We are not in a hurry. You have told me that the deadline will not matter. Okay, so see you on Thursday.
Please, sir, can we get your slides that you are reading
After the lecture.
from?
After the lecture.
Thank you. Thank you, sir.
Yeah, yeah.